Getting your steps in.
Stand by, Chris. They're going to bring you on in a bit. Just hang there, okay?
Hello and welcome to Harris County Criminal Lawyers Association's Reasonable Doubt. My name is Murray Newman and I am your host tonight. My normal co-host, Justin Harris, is not here tonight because apparently they have these things called open houses where you go to show how much you care about your kids, and he is apparently really interested in doing that. So you've let me down personally, Justin. We miss you, but we will see you next time. And I know that you're sorry to miss this show because we actually have a great show tonight with Harris County's #1 power couple, Janie Maselli Wood and her husband, Ted Wood. Thank you guys for being here tonight.
Thanks for having us.
Thanks.
And you guys, everybody knows you, everybody loves you. You guys are kind of an institution here in Harris County. Y'all both work for the Public Defender's Office.
Yes.
And you pretty much have since the beginning, correct?
I have since the beginning. When did you start?
2015.
So, and I was 2011.
Okay, so you're an OG with the
Yes.
PDs, OGPD. And I want to hear a little bit about y'all before we start talking about the topics at hand. So tell us, you have a really amazing backstory, Janie.
Do I? I don't think so. But I love working at the Public Defender's Office. I wish it had been around when I was a new lawyer. But I graduated from University of Houston and I started at the prison as a public defender for then inmate legal services. And then I went to work for Judge Charlie Baird at the Court of Criminal Appeals. And after he lost, I came back and had my own practice doing a lot of capital work and appeals. And then when the PD came, I was like, you know what, I'm gonna apply. I was 47. So if you do the math, I'm 60 now. But I love working there. I have taught at U of H as an adjunct since 1999. And I write Dale Connor's book, Texas Criminal Offenses and Defenses, and I think that's about it, pretty much. And I'm married to the nicest person in the world.
So nicest person in the world, tell us about yourself.
Well, I'm a 1991 graduate of Baylor Law School. My first job out of law school was to clerk for the 7th Court of Appeals in Amarillo for Judge Brian Poff. And following that, I served as the Randall County judge. The county seat of Randall County is Canyon, but it takes in half the city of Amarillo. And I did that for 2 terms. So it was a lot of commissioner's court stuff, budgets and taxes. I did a little bit of judging in probate cases and guardianships and juvenile cases and that kind of thing. After 8 years doing that, I went to work for an outfit called the Texas Office of Court Administration, and they're based in Austin. I was there for 13 or 14 years, and I retired in 2015. I actually met the rule of 80, and when you counted up all my government time, my age, 55 at the time, and my years of service, 25, that was 80. So I retired, but I wasn't ready to, quit. And so I came to work, fortunately, for the Harris County Public Defender's Office, and I love what I do. I've been here now almost 9 years.
And what sections are y'all both in at the PD's office?
Well, I am the legislative liaison. And in fact, I was in Austin today on some legislative matters. So that's what takes up most of my time. When I have other time, I do appeals.
Okay.
And I'm chief of the appellate division, not his boss. He does take overflow because it does get busy, and we have found in the last few years since COVID and Harvey that the things being tried are capitals and continuouses, so they're all big records. So he does help out. We advertised we're hiring more, and so it's a great job. I mean, the things we're going to talk about today, no one in private practice could ever be interested in because they would not make any money.
Yeah. Well, and you know, and that's great to have the PD's office. You know, I always have to reluctantly admit that I'm eating my words when it comes to the PD's office, because it was coming into existence right around the time I was about to get fired from the DA's office, and I was like, well, apparently just God doesn't want me to work in Harris County, and I thought that the PD's office would just kill us. Anybody that, like me, who was just starting out of defense practice. But you guys, and I think a huge kudos go out to Alex Bunnan for turning the PD's office into such an open arms, welcoming resource to not just to indigent defense, but to everybody in Harris County. And it really has recruited some top tier people such as yourselves. But I do have to know, who's in charge of supervising Scott Pope?
I am.
Oh, man. Do you get a bonus for that?
Scott Pope is our most valuable player. He's our MVP. He does all the things we don't want to do.
Well, he's my kid asked me today, my 11-year-old, actually my 10-year-old asked me who's the funniest person I have ever met, and actually the first one who sprung to my mind was Eamon Bakewell, but Scott Pope's right up there with it as the funniest person I've ever met in my entire life. He's a good egg, and he's disarmingly smart. People don't realize, because he's so funny, that how intelligent he actually is.
He's a great colleague. He helps everyone. I mean, we're very lucky to have him.
So speaking of the problems that you guys are willing to tackle, because there's not a lot of money in it, so the private defense bar is probably not going to do it. You guys reached out to us because you had something that you wanted to talk about involving the district clerk's office.
Yes, and it has to do with the standardized felony judgment form. And I know a lot of people are like, who cares about the judgment form? It's so important. There's so many things that have to be correct on that judgment form. And I know Ted has some history because OCA, he actually helped create the standardized felony judgment form.
Well, and I'm excited to have you guys as guests, but we've invited one additional special guest to talk about that, and that is former Harris County District Clerk. Man, I hadn't seen you in a while. Chris Daniel, how you doing, man?
Hi, Chris.
Hi, guys. Doing good. But I bow down to Ted. Ted helped basically save the district clerk's offices across the state in standardizing these forms and making sure it's done right.
So our current district clerk is Marilyn Burgess, and she's been controversial, especially with the defense bar in the criminal world, with a lot of things that she has changed. And for those of you all that historically don't know, Chris, were you 2 terms?
2 terms.
2 terms, and Chris was an excellent district clerk. He had something extremely streamlined, very responsive. If you even made fun of him a little bit on Facebook or Twitter, he called you within 15 minutes to see what the deal was. A very responsive public servant, and things have gone a little bit downhill since then, culminating in this issue you want to talk to us about tonight.
So I'll just give a background because I don't think Chris knows where we're coming from. What we found was we have the standardized felony judgment form, and it's standard. Every county must use it. And Harris County decided to change it.
Okay, first of all, explain to those of us who aren't lawyers, well, I am a lawyer, but the people who are watching that aren't lawyers, what it is. In general, what are we talking
Ted
about?
knows more about that.
Yeah, I'll take over here.
Okay.
If you look at chapter 42.01, section 42. Article 42.01 of the Code of Criminal Procedure, it lists like 29, 30, a number of different things that must be in a written felony judgment, criminal judgment. And then there are a lot of subsequent articles in chapter 42 that list additional things that need to be in the judgment. So it was decided back in 1985 that it would be a good idea for this to be a standardized judgment. And
Wow.
oh, okay, great.
Chris is man. Wow, look at that. Chris has got the effects.
So I told you there
for
were a number of 29 or 30 or more things that need to be in a judgment. And if you go down after these numbers, you get to something called Section 4, and I think you can stop. It's about 4 lines, 5 lines from the top, and
Yeah.
it says the Office of Court Administration shall promulgate a standardized felony judgment form, and that was 1985 when they said that would happen. And then a few years later they said, by the way, courts that enter a felony judgment need to use this form.
And to simplify it just a little bit more than that, for the layperson, the judgment is the document that basically memorializes a person's plea of guilty or a finding of guilt. That's when you talk about something going on your record, this is the record. And so when we talk about what you did in 1985, there was, if I understand correctly, you're saying that there was legislation that said the records across the state all need to look the same and have the same information in them.
Exactly. And so when I worked at the Office of Court Administration, I was an assistant general counsel. I was specifically tasked with promulgating that form. And when there are changes to legislation, we would try and incorporate those into the form. So I'm very familiar with how this works and what it should look like. And that's part one of the background for where we're going. Part two of the background has to do with the history of an ability to pay statute. And this goes back to 2017 when legislation was passed that said we want to have courts at the time of sentencing conduct an ability to pay inquiry to see if the defendant can afford to pay the court costs and the fine that's been assessed. And the reason that that got passed is because it was an attempt to find out up front if defendants could afford to pay, rather than order them to pay and then find out during the process that they're not able to pay, they can't pay, and you have to do things like capias pro fines and things like that. So this was an attempt to cut that off. And so that legislation, the sponsor was Judith Zaffarini. She's still in the Senate. She's really the driving force behind this legislation. It went into effect on September 1st, 2017. So we're just about to September 1st, 2024. It'll be 7 years that that has been the case. And this is something that judges, whether they're district judges or county court at law judges, are supposed to do sua sponte. They shouldn't have to be prompted by anybody to do it. What we are finding, though, is that it's rarely done.
And so what are the consequences just for the general public? What are the consequences if they're not done? What kind of trouble can a defendant get in if there wasn't such a finding and suddenly they believe that they didn't pay some sort of court cost or fee that they were owing the court? What could happen to them?
Well, certainly if they're on some sort of deferred adjudication, one of the requirements, one of the terms of their deferred adjudication is that they pay their fines and their fees, and you are subject to being adjudicated. That's one of the reasons. Also, if you're on community supervision, that's usually one of the terms of probation, is to pay your fines and fees. And if you're not able to, that can be another reason to be revoked. So these are serious consequences that can happen. Even if you are not on deferred or not on probation, this is just money that you owe, and you're on the hook for it. And sometimes if you are sent away to prison, there will also be an order that says we're going to take money from your inmate trust account, so to speak. A lot of times the money in there is put in by inmates' families. But that's what could happen. And so the way the legislation is written is that there's supposed to be an ability to pay inquiry, and usually for our clients, well, they're indigent, else they wouldn't be our clients.
Right.
Okay? And rarely does that indigency change from the time an attorney was appointed to the time that they're being sentenced. So most of these people don't have the means to pay, and the judge then has 3 options. The judge can outright waive the costs, or the judge could say the person, number 2, could do community service in lieu of paying the costs, or third, they could be told that they have to pay this at a later time, or some combination of the 3. But that's what judges are supposed to do, is engage in this inquiry. When it doesn't happen, well, it's certainly not following the intent of the legislature, that's for sure.
He's got the bill up. And I will say this, it's shocking how we don't do it in Harris County. And a few times I've coerced lawyers to do it. And amazingly, the judges, they're like, oh, okay, and they do it, and then they waive the costs.
Right. It's not something that the judges would necessarily be opposed to. It's just we forget to go through that step.
Except they have a bench book that the Texas Justice Courts trainings.
Well, Texas Center for the Judiciary.
Texas Center for the Judiciary. I've looked at that bench book, and that's part of the colloquy after they're supposed to do that ability to pay inquiry. And it's supposed to be, and I don't want to steal your thunder, but Ted and other people in the legislature went and said, well, it's not being done. And so Senator Zaffarini passed another bill in 2019 that said it had to be done on the record.
Okay.
And James,
and most pleas are not done on the record.
Right.
Janie will explain some of the challenges that we've had in appeals on this matter, but I wanted to kind of bring these two ideas together. The first one being the felony judgment form, and the other one being the ability to pay inquiry. And as I told you, my role, this all happened after my time there. I left OCA in 2015. But in 2017, when this legislation happened that said there shall be an ability to pay inquiry, the OCA did the right thing. They said, okay, this is a new requirement, and we are going to put boilerplate language into the written judgment form that says, after having conducted an inquiry into the defendant's ability to pay, comma, this is what I order the defendant to do. And there's not a checkbox for that. It's just a statement in every single written judgment, but it doesn't reflect what's really happening. But it was well-intentioned because it was assumed that judges would do it, but in reality, they're not.
So what would happen is we would get a record, and we'd look to see if there's an ability to pay inquiry, because it's supposed to now be on the record, and there's none. So we would challenge it on appeal. And I just want to read you the language we lost. I mean, we are the biggest losers.
Multiple times.
Yeah, multiple times. But it's like on appeal, the defendant asserts that nothing in the record shows the trial judge considered his ability to pay these assessed costs. We disagree. The recitals in the judgment of conviction reflect that the trial court ordered him to pay costs after having conducted an inquiry into his ability to pay. So they used that boilerplate language to say you lose. And man, we lost. I only brought 4 losses, but we kept challenging it as many different ways as we could because it's supposed to be happening, and we just kept getting shot down and shot down. So we did. What I learned at the PD's office was sometimes you can't win on appeal. We started talking to OCA and saying, hey, why is that sentence in there? Because it doesn't reflect what's happening.
So what year is this that you're talking about, this fight?
This is like from 2019 to 2022, Ted.
Mm-hmm. Right.
So these are like 4 years of just getting shot down, the Court of Appeals. Oh, well, the judgment form shows it was done. The judgment form shows it was done. And so Ted, having worked at OCA, reached out, and I know other people reached out and said to OCA, look, you came from a good spot. You wanted these ability to pay inquiries to be held, so you put it on the judgment form, but now it's hurting defendants.
And specify how, exactly.
Well, because with that sentence on the judgment, we can't win an appeal because they said, well, that it says on the judgment. We give that presumption of regularity. So you can't prove it wasn't done, and the judgment says it was done.
Let me give you an example, Murray. We might, have a defendant. We're handling his appeal. He's been ordered to pay a $5,000 fine and let's say $500 in court costs. So $5,500. He's on the hook for that. There was never any ability to pay inquiry conducted in the trial court. And so we would bring up as an issue on appeal the fact that that didn't happen, yet our guy is assessed this $5,500. And we are asking, the relief we're asking for on appeal is that the case be remanded to the trial court to conduct an ability to pay inquiry. And if that is really done, then either those fees are going to be waived or possibly some other option besides paying it. So that's how it was that's how it's hurting our clients.
So the issue then, because I'm an Aggie and I'm a little slow, and Chris, I know you're a Longhorn. I don't need your.
He gets it.
I don't need. Yeah. Is that the district clerk has added language as if it's been done?
Well,
or?
no, what happened was OCA, the official standardized felony judgment form, had that language.
Okay.
But then after numerous people talked to them, they removed that language
Okay.
on February 23rd, 2023.
And by that language, she means the language that says after having conducted an ability to pay inquiry.
So they just excised it. And so OCA, and Chris had pulled down like where you can get the standardized felony judgment forms, the new judgment form, and there's a little date on the bottom, effective 2/23/23. They took that statement out.
They being
OCA, because
Right.
they promulgate the form. They're the only ones that can change the form.
Okay.
So that happened February 23, 2023. Well, I've been watching, and all of a sudden I see in June or late May, the new form's out. And so, but Harris County's not using it. So I email the 7th floor.
What does that mean?
The 7th floor is the Harris County Office of Court Administration. And I email their staff attorney at the time was Candace Horsey, who had worked at the PDs. I knew her. I said, hey, there's a new felony judgment form. Why aren't you using it? So she's on vacation and she gets back to me and she's like, oh, well, let me email the district clerk and see. And she does. And there's some discussion with a member of the OCA about the new form. And so we have been able to backtrack that on July 14th, 2023, Harris County started using the new form. But I didn't see it because I do appeals. So I'm not seeing a judgment for months. So Harris County's using the new form. I get an appeal. It's March 4th of this year. And I notice in the bottom left-hand corner, it says it's the effective 2/23/23. I'm like, yes, the new standardized felony judgment form that has taken that language out. So then I read it and saw that that language was in there. And I was like, wait a minute. So then I went back to OCA, pulled down their form. It's not in there. And they made like 6 grammatical changes as well, very minor. All those are the same in Harris County. The only thing that they did was add that language back in after having conducted an ability to pay inquiry.
So.
Oh, look at Chris's face.
So I was about to say, let's throw it to Chris here. Tell us how this would work on the district clerk's
How
end.
does this work?
It's very simple. When OCA promulgates a form, we use that form. It goes on our website. It goes into our database. It goes into JWeb. It goes into GIMS that existed at that time. It goes to the clerk to be used, and it replaces. This is not just leaving someone's name up on a jury summons 4 years after they've been elected. This is a form that's necessary. That how?
So does this take like a willful omission or commission? I mean, is this? I mean, what do you see? What do you see as the method and motivation happening here, Chris?
I'm assuming that one of her co-chiefs of staff knew best and decided to put that language back in there because she knew best.
And I wanted to say this, Murray, that when you go to the OCA website and you take that form that they've created, it's basically a Word document. And you can go in and add a sentence if you were so inclined. Now, you shouldn't, because as Chris has said, that's the form, you use the form. But what happened here is the new form was altered. Somebody put that sentence back in. And we've been trying to get to the bottom of that because, that's harmful to our clients. And Janie can tell you about her efforts to try and get to the bottom of the problem.
And it's harmful to our clients because we're back where we were when we challenge it on appeal and we lose because it says it was done on the judgment form. And OCA fixed it. They heard other people, not just us, and said, all right, we're going to take that off. And somehow Harris County put it back in. So I emailed on March 4th Judge Bell, because she's the presiding judge at the time. I said, hey, and I laid it all out. And she forwarded it to Andrew Smith, the staff attorney now for the Harris County Office of Administrative Courts. And then I got this email after, it's really, so I emailed her, like the whole thing, and she forwarded to me this email. I was not included on it. And it says, Judge Bell. And this is from Andrew Smith on March 6th. I misread Ms. Maselli's email. Ms. Maselli was correct. District Court Office's form contains language that was removed by OCA. This morning, I informed the District Clerk's Office, and they have already indicated they're going to start using the correct form. Therefore, there's nothing that you or the Felony Board needs to do. My apologies for the confusion, and this is my favorite part, kudos to Ms. Maselli for catching this and bringing it to our attention. But
mistakes happen, but in this case, it's willful.
Yeah, it's not a random mistake because all the other minor changes were left. They deliberately went in and added that sentence. So I decided I would be Sherlock Holmes and I would find out who did it. And I filed so many open records requests that they told me it was too many. So then I had my friends across the state file them. I received 0 documents. Nobody has ever written an email in the 7th floor or the district clerk about the standardized felony judgment form. The last open records I did, they went to the AG because I said, I want every email where my name is mentioned from this date to this date, and they refused and went to the AG, and I just won that, but I still don't have it. Chris, this just doesn't happen by mistake. This is...
No.
How?
You are correct.
How would this happen?
And why would it happen?
Again, I'm speculating, but I think a certain chief of staff thought they knew best because of their criminal background and because of who their husband is, and they decided that the language was necessary, and so they decided to fix the issue themselves instead of following what the OCA has promulgated to the entire state of Texas.
But if you're to back this up, though, by not following what the OCA dictated, what material gain does it give the state of Texas through the district clerk or the district attorney, or who benefits from not changing it other than I'm smarter than y'all? It's
really inside baseball. It would have to be someone that knows that we have been challenging this in appeal after appeal after appeal. We are relentless. And it has to be someone that knows that we have been challenging that sentence. I mean, because it's so deliberate. And with that sentence back in the judgment, we lose again on appeal.
And I'll say this, Marie, to your point about what's to be gained by this. From an overall perspective, more money is coming into the system from criminal defendants than it would otherwise. Now, does anybody in any Harris County office personally benefit from that? I don't think so.
Right.
But that's the result of it. And so right now, you know, Janie read the email where it said kudos to Ms. Maselli and so on. And
can we cut to Janie for that with the jazz hands?
Yes. Kudos to Janie Maselli. Yeah. I will put that on a T-shirt one day.
Yeah.
So the judgment now reads correctly. It's been corrected. And it was an overnight thing where they said, we're going to correct that. We still wanted to know, how did this happen and who was behind this? And what is hard for us to understand is that in these open records requests, we ask for any communications in the district clerk's office or in the administrative office of the courts or back and forth about the standardized felony judgment forms and the change to them or the new judgment forms or anything. We never got anything more about it, nothing. And it's hard for me to believe that you could institute a new form in the system in 2023 without any emails being sent anywhere. So we're wondering about the accuracy of the response we get that says there's nothing that we have.
So this is a little bit of a departure. And by the way, Janie, Molly Bagshaw says she is your biggest fan.
Thank you, Molly.
So a while back, when Franklin Bynum was on the bench, he got into it basically over the way that that intake at the DA's office was swearing off on their information.
Right.
And I remember, I'm not an appellate guy. I don't possess 1% of the knowledge that you guys do or that Franklin does, although that pains me to admit. But I remember after Franklin explained what he was criticizing, I said, it sounds to me like you're right, but this is a system that's too big to fail. Like, they cannot acknowledge this because it would he basically said they were doing intake all wrong and that it needed to be restructured, and that if they did it, if they followed the rules that he had, it would collapse intake. And is there a possibility that there was reluctance to change this because it could jeopardize judgments? Because you've had success on some of these things that are seemingly facially technical errors, but you've made them pretty substantive in the past.
Yes, but it makes me wonder. Are all the judgments between July 14th of 2023 and March 7th of 2024 subject to a nunc pro tunc? Are they invalid? If I'm a judge, that judgment is mine. I would be very upset with the district clerk's office and I didn't really want to go there, but I might tell you that 37.10 of the penal code is tampering with a government record.
Well, yeah.
And this is that statute that says everyone uses the same felony judgment form. Harris County changed it. And, my point is it changed it to hurt criminal defendants, bring in more money for the county, or some other nefarious reason. I don't see any good, there's nothing good. But is it tampering with a government record? Yes.
Okay, so this is an honest question because I don't know. But let's say that I'm on deferred and I get a motion to adjudicate and I want to attack it as an invalid judgment because of the language. Is this a vehicle to attack the validity of that potentially?
Oh my God, that would be so fun.
Yeah.
Wouldn't that be great? I might start that
Did
tomorrow.
I just come up with an idea?
You did.
See, sometimes the dumb guy wanders into things.
No, the people who are there every day, we're sort of removed. Even when they moved us out of the courthouse, I'm down the street, I'm up in my office just thinking, why are they doing these things? But that's what I'm saying is, if I'm a judge, I'm offended that you messed with my judgment because I signed that.
Yeah.
And the clerk's office, it's not a mistake. It was deliberate. And apparently no one knows who did it, or my open records myriad of requests, I'm talking 100, yielded nothing.
And I wanted...
That's impossible.
Yeah.
Is it?
That's impossible.
I think so too. And Chris, I wanted you to put up another statute if you can. It's section 2 of Article 42.01. And what this says is that, I'll wait for you to put it up.
He's if you watched Wise Guy, he's the man in the van. He's the guy that's doing it. Chris is doing all. He's even got the headset. He's doing all the tech support.
While he pulls that up, I want to read Texas Penal Code 37.10A1. A person commits an offense if he knowingly makes a false entry in or false alteration of a governmental record.
So if we were to look at this, and let's say we just waved a magic wand and we knew who all did this, could this be something that the clerks assigned to the courts could be guilty of?
No.
Could this be something
because
that
they just use what's given to them, right, Chris? It's somehow loaded up. Whoever made the change had to put it loaded up. So it wouldn't be a clerk.
This would have happened between Tracy Hopper and her team and whoever instructed Tracy Hopper and her team.
So go to 4201, section 2. We're almost there.
There it is.
Oh, there it is. The judge may order the prosecuting attorney or the attorney or attorneys representing any defendant or the court clerk under the supervision of an attorney to prepare the judgment, or the court may prepare the same. And I think Chris will confirm what I'm going to tell you, that in Harris County, the clerk's office prepares those judgments. Is that correct, Chris?
That's correct.
That's correct. And so that's their responsibility. That in some other counties, the prosecutor does do it. But the judges are not really involved in preparing the judgment. They sign the judgment. It does belong to them. But I would be flabbergasted if any judge knew that this minutia had happened. I just don't think they would know that. And so, but back to the point that Chris just made, that it would be impossible to implement this new form without some email correspondence somewhere that this is happening. And so that's why we were so shocked that in our efforts to find out what had happened, that we got nothing, that nothing is responsive to your request for information about this.
I'll give you a real example of that, just so that we can put some substance to this. When Ted was in charge of the OCA in his capacity, Farrah Martinez was my legislative director, and there would be hundreds of emails between her, the programmers, OCA, between the judges point person, and all of this back and forth information that could easily be open records requested. And it has been open record requested during that time period. And so she obviously doesn't work for the office anymore. That's why I'm using her name specifically. But there are people in that office who are not just Marilyn Burgess, not just the chief of staff, not just the head programmer, whose names should easily be open record requested to get these paper trails. And the fact that there's not a single document responsive, that's impossible.
So Chris, let me ask you this. Putting on our Watergate hats, is this something that gets done without the district clerk herself being aware of it being done?
Ooh, well, she didn't know what the word nunc-pro-tunc meant when we interviewed last with the Houston Chronicle.
Someone's throwing a little shade, just a little bit.
Hey, she admitted it. That at the end of the day, this could be too in the weeds for her to understand that, hey, we made this change because we think OCA is wrong, and therefore we're going to stick it in there anyway. I don't think, it pains me to say this, but I don't think she's smart enough to know that they did that.
So Chris, let's put you in a hypothetical situation. You're district clerk, you're watching TV, you had no idea this was going on in your own office, and you see Janie and Ted up here talking. What is your gut instinct? Is it I'll fix it tomorrow? Is it I hope I don't get indicted? What would be going through your mind at this point?
It would be a phone call immediately to Tracy to say, hey, do you know about this? When did this happen? Why did this happen? And then following up with who told her to do that.
I mean, obviously, you take on the role of district clerk, and a lot of people don't realize just how many responsibilities you do have, and it's quite a few. But you take on that position when you run for it, knowing that you are legally required and responsible for a lot of things, and it's more than just being a pretty face on a website or a billboard. What duty? I mean, it seems to me that this would be one of those, I can't cuss on TV, but oh crap moments. Like on a scale of 1 to 10, how bad would you be thinking right now in this instance?
I'd be thinking in the same vein as the former district clerk of Brazoria County, who was accused of meddling with shuffling the jurors, and how many thousands of cases were jeopardized in Brazoria County based on that one allegation. I think it's in the same vein.
You think this is big?
Big.
Thank you, Chris.
Think about it. How many people have maybe missed a payment inadvertently, or because their bank changed, or they moved, or they didn't get a notice,
or they're just broke,
or
they're just broke.
Or they're just broke. And
I can remember one time, because I think that there has been a tendency, I've seen judges be very cavalier about a person's financial status. I once had I recall once having like a 17-year-old charged with a burglary that ultimately he was exonerated for. And I mean, he was a high school student, and they had started something about like you have to pay into the funds even though you're indigent. You had to do some sort of payback system. They did an article on the Houston Press a while back, but I remember the judge saying, no, well, he must have said he must have had enough to not meet the threshold for indigency because we're requiring him to pay back. And I was like, how much below zero does he have to be to qualify? But judges get pretty funny about this. Some judges, not all, but I've seen them be very flippant about that. Like, we're just going to order it. And I think that they kind of have in their head that they wouldn't ever revoke somebody or incarcerate someone if they couldn't pay, so that it's therefore not that big of a deal. But it is.
It's huge. And the fact that Harris County, I think it's a progressive county, that our judges don't do the ability to pay inquiry is like tremendously disappointing. And I would also like to say, like Ted said, even if you go to prison, they get the money. And if you don't pay from your inmate trust fund, if you have no money, when you get out, they give you a letter. Report to the district clerk and set up a payment plan. There's like no statute of limitations. You owe that money. And that's why we need to do these ability to pay inquiries. And we need to find out who changed the standardized felony judgment form.
I mean, is this worthy of a district attorney investigation into it to see who changed what and when?
The more they stonewall it.
Look, I think it is, and especially because of the lack of response that we got to our open records request, because we were interested to know, is this something that Marilyn Burgess herself is even aware of? Maybe, maybe not. And we thought if we have some emails and we see what's happening, we can tell that. We didn't get any emails at all. It's like it never got talked about again, yet somehow it got implemented. So we're just as curious as the next people. Who was really behind this
And
change?
what would have happened if I never read the new judgment? If I just said, oh, they're using the new one, great. But like me, I'm like, oh, I'm so excited to read where it's not in there. And then it was in there. I mean,
Thank God for nerds, right?
yeah, thank God for nerds who read everything. And so then I've just been like, I mean, I'd like to think I'm Nancy Drew. I've failed miserably. And so I was like, well, how can we get the light of day? I'll go on Murray Newman's Reasonable Doubt.
And 14 people will see it. But you know, I always joke about viewership on this, but we actually do have a lot of people that watch out. And we have judges now, and Judge Morris is watching. She commented, she said that I may have stolen her idea about, are these judgments invalid? I promise I came up with that on my own, Judge. I did think of that on my own. But I mean, it is good to have members of the judiciary watching and taking note, because, you know, you have to bring these things to light somehow. Even if it may not be the sexiest story, it's still an important one.
Well, I still think it is the sexiest story, but again, nerd alert.
You're right.
Yeah, and we appreciate this format because
Right.
I tried to explain this to a friend of mine while playing golf.
Yeah.
And it's just too complicated to explain.
Did it throw his game off?
Well, his
fall
game and
asleep?
my game are already way off,
yeah.
okay? But you have to almost sit down and kind of go through the statutes and give some background. It's not a story that just immediately jumps out and grabs you.
And honestly, Chris, you being here has really helped, because
Definitely.
a lot of this is in a vacuum for us. So I'm glad to hear from you that it just can't randomly happen.
No.
Yeah, and I wanted to say this, Murray. Janie talked about working at the public defender's office, and we're able to do some things there that you couldn't do as a private practice attorney,
Right.
because chasing this stuff down takes time
Sure.
and effort. And so we're about trying to make systemic change. And one of the systemic changes we're interested in is that our indigent clients don't get saddled with all these court costs and fines that they cannot pay back and that negatively affect them. So we work on that in two fronts, which is why it's kind of cool that in addition to my main responsibility as a legislative liaison, I also do some appeals, because we're working on this on both fronts. We work to get the law in the first place and to get the law amended in 2019, and worked with Senator Zaffarini's office. And then we've worked with OCA, and then we've tried to do appeals. And so on all these fronts, we can try and effectuate systemic change that is not going to benefit any one particular defendant in a huge way, But system-wide, on a macro level, this is going to be huge, huge changes that we're very interested in.
So we do have a question from the viewers. Nina, who we talked about earlier, said, can you all explain a little more clearly why this matters for defendants, or walk us through an example of a case or something where this could negatively impact an indigent defendant who gets this finding made for them?
Well, so an indigent defendant doesn't get the ability to pay hearing. All right?
All right.
It goes up on appeal. Ted or I get it, and we're like, oh, they didn't get their ability to pay inquiry, and they've got $1,800 in court costs. I don't know if y'all know that, like, when the state subpoenas like 50 people and it's reset 3 times, the defendant pays $5 per state subpoena. They pay for that. And so we're like, all right, my client's indigent. He's had court-appointed lawyers the whole way. I'm going to challenge this because he did not get the statutorily required ability to pay inquiry. But then that language is on the judgment, and so the Court of Appeals just routinely, all of this, it's like, well, the recitals in the judgment reflect the trial court ordered him to pay the costs after having conducted an inquiry into his ability to pay. Even though we know it didn't happen, because the judgment form said it happened, you lose.
So basically people are finding themselves financially on a hook over a lie.
Right.
And we know that the government's going to harass them till their dying day or they get paid.
And these ability to pay inquiries, people fought long and hard for these hearings. I mean, this wasn't just like, oh, let's put this in the ledge and it gets passed. I don't know how many years, like Judicial Council and Texas Appleseed and Texas Fair Defense Project. We finally, and I say we, they got a change of heart. It used to be, let's get as much money from defendants as we can, to, hey, we're ruining people's lives by these court costs. They can't pay. They used to, if you owed court costs, they don't do it anymore, but if you got pulled over, they could have a capias pro fine, which is like an arrest warrant for not paying your court costs, and you're just taken to jail. Oh, you have children in the car? CPS takes them. These things have huge repercussions. For most people, you could come up with $300 or $500, maybe $1,000. For our clients who are indigent, they can't.
Right.
And so to deny them the hearing and then pretend like it happened because there's a statement on a judgment when I know it didn't happen and the Court of Appeals accepts that, I'm sorry, very upsetting to me, because we have a duty as public defenders to help our clients, help indigent people, and it's just like a fraud. It's a fraud.
Well, it's definitely a fraud, but going to an earlier question that I had is, are we doing pleas wrong? Like,
Yes.
we're still doing pleas, because on most plea paperwork, there is, the client initials, you waive the right to have a court reporter on there, but under this language, it sounds like it doesn't matter if they're waived, it shall be done.
Well, I say this, yes, you're right, but if you could get the DA to agree, say, hey, will you let us waive court costs? I'd waive my court reporter, right?
Yeah.
So you could do that. Are you asking for the ability to pay inquiry in every one of your appointed cases?
I'll be honest, no.
Right, and you're not the only one.
I didn't figure I was. I'd have picked up.
So part of what we're trying to do here, besides exposing this,
It's getting meat.
Yes,
No,
you personally.
Yeah, but no.
Besides exposing what happened with this shenanigan, I'll call it, is number one, we'd like to inform the district judges, to the extent they don't already know, that this is an obligation to do this in every criminal conviction, sua sponte.
Yeah.
And number two, to inform all the defense attorneys that we hope that you're asking for this. If your client gets convicted, and maybe that's not what you hoped for, but there's another step, and during sentencing, please ask that the judge conduct an ability to pay inquiry.
I want to say that part and parcel of what Judge Danny Lacayo does on his pleas is a lot of times he wraps it up by saying, I find that you're indigent.
See, thank you, Judge Lacayo, thank you. And all judges should do that, because
And if I'm leaving any judges off that
We're
do
sorry.
that, I did that. But I distinctly remember Danny doing it. Judge
Indigency
Lacayo.
travels with the defendant unless there's affirmative evidence they're no longer indigent. And so if they've had a court-appointed lawyer and then you appoint the public defender, you can presume they're indigent. And the statute says at the present time or something like that, Ted?
Oh, if they can immediately pay.
Immediately pay.
Right.
And so
I love that he knew that off the top of his
I
head.
love it too. Like
just
I will just text him randomly, what's that statute, blah, 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 in the government code? And like 1 second later, he's telling me.
Yeah.
We lead an exciting life.
I mean,
And I wanted to tell you,
this is karma that you two have each other.
yeah, it is. When we get an appellate record and we're reading the reporter's record and we get to the sentencing portion, we hear the judge hand down the sentence, how many years in TDC and if there's a fine or something. And then usually that's it. They say, okay, well, thanks everybody.
Right.
We're off the record or what have you, or we're done.
Assuming there was a record. But,
Yeah, so, but there is a record of that.
Right.
But what we don't find in there is any ability to pay inquiry, which is now required to be on the record, but we just don't find it there. And the problem was when we complained about that, because of the language in the judgment saying that an ability to pay inquiry was conducted, the courts of appeals look at it and say, well, you haven't brought forth a record showing that it did not happen off the record somewhere.
Right.
Well, true enough, how am I going to show that? I can't.
I know, I wanted to say something like, well, you say it wasn't preserved for appellate review. How can you show it wasn't preserved off the record? I haven't had the nerve to do that yet.
I mean, just playing devil's advocate, like could an affidavit be put forth from the defense attorney that it wasn't done?
Well, you'd have to do it in a motion for new trial, but it wouldn't give you a new trial, so it's not really cognizable on a motion for new trial.
Okay.
And then on appeal, you can't add anything into the record.
Yeah.
You can't do it on habeas because you're not attacking the conviction. See, it's
kind of in a little gray area.
right, and we have tried every different way. I mean, like, we've been working on court costs alone. I mean, this is how I started. This is before he worked for the PD. We were eating dinner one night, and I'm just eating, and he goes, I think most of those court costs are unconstitutional. I was like, what? And literally, that's how this began.
To have been a fly on the wall at that dinner,
But Janie, to your point, you remember when we battled over the cost bill and
Yes.
how many emails, how many documents, how many cases were related to that? How
Right.
can there not be anything responsive?
I know. It's crazy. Yeah, Chris, he had his hands full with us over the cost bill.
But nobly so. Look, it was a good issue, and that's my point. Is there were so many pieces of data
Right.
related to this.
Yeah, I mean that's the difference between someone who's willing to engage and argue with you
Right.
versus ignore you and pretend that they didn't do it. I mean,
And
I love Chris, but I've disagreed with Chris plenty over the years. But I never saw him back down from addressing his point of view. So
I mean, I've just been really disappointed. And maybe that my expectations were too high. I thought, hey, who did this? And I mean, the responsiveness to this open records, it's just some random emails that have nothing to do with the request. It's bizarre.
So we're down to 4 minutes. I told you this goes by really quickly. I have a couple of follow-up questions. Is this something that you see pervasive across other counties in Texas that you're aware of, or is this just a Harris County problem?
I would like to say quickly, when I started this, I emailed my friends all around the state. I said, send me your judgment forms. All the other counties are using, not even the 2020, some of them are 2017 in Lubbock. So I'm actually glad we're using the most recent judgment form, but I will also say that other counties are better at doing the ability to pay inquiries. Other, like, smaller counties, especially in like West Texas, we always hear how they do it and they win.
So we have several judges who are watching tonight who have commented in. We really appreciate that. Should the message go forth, put your pleas on the record starting tomorrow and add this? I mean, is that a big takeaway from this?
you can do that, or get the DA to agree to waive costs, ask the judge to waive them, and then I don't need a record.
Well, of course, if you ask a bunch of DAs tomorrow in court, they're going to be like, do what now?
Yeah.
So is the more effective and more quick remedy to let's go on the record for these findings?
Right, but what I've heard is that the judges don't want their court reporters to be doing that.
I bet you that more judges don't realize how important it is.
Okay.
If given the opportunity, that would be my thought. Just like I don't have any aversion to doing it. I can fess up and say that's something I didn't do because I wasn't aware that I needed to be doing it. I've learned this is worth the price of admission.
It's statutorily required, and if you want to follow the law, it needs to be done.
Well, I mean that's an incredible message that needs to obviously be shared. And I don't recall us having this many viewers in a long time. So I mean, we got a bunch of fired up nerds that came on to watch you guys too.
Sunshine might have sent something to the entire PD's office,
Okay.
and I came back because everyone was saying to me in the hallway, "Hey, you're going to be on reasonable doubt." I was like, "How do they know that?" And then I realized that it went to 287 public defenders employees.
Well, that's fantastic. So where do you go from here procedurally on this? You got two minutes. Who's your next victims?
I haven't given up finding out who this person is or what happened here, but I feel like I don't have this, like, I'm not a reporter that can just call up Marilyn Burgess and say what happened. You know, I tried to do open records. I tried to talk to people. Nobody will tell us anything. But, like, he and I will not give up, correct?
That's right. And I would like to see an investigative journalist of some kind go to Marilyn Burgess, she's the top of the district clerk's office, and say, what do you have to say about this? This is the problem that's been laid out.
Chris, can you help them? Can you help them get some traction on this?
I sure hope so.
All right.
Thank you, Chris. It's great to see you.
Of course.
Yeah, thank you very much for joining us and for all the visual aids. I mean, we need to hire you full time on
Yes.
this. That was awesome. All right, well, folks, this has been a very exciting and very enlightening episode. People are fired up. I love it. I love it. It's fantastic. Ted Wood, Janie Maselli Wood, thank you so much for being our guests, and we will see you all in 2 weeks. Thank you all for tuning in.